Today I'm going to give you the tip for the best use of your money, best use of $500 that you will ever spend in preparing for trial. So it begins with a story about a drowning case. Two little kids, 5 and 8 years old, drowned, and their siblings watched them as they and their babysitter drowned in the Hudson River of New York. Earlier that day, the 4 children's mother had dropped them off with the babysitter to go to a Yankees game. And when we were preparing the case for trial, we thought we had the great case. It was perfectly set up because the area where the children drowned was a very dangerous hidden hazard and never should have existed. So we had a great case. But when we presented it to a focus group, they disagreed and they found against our case. And why? Because the mother had dropped off the kids to go to a Yankees game. And in the jury's mind, that mother was completely negligent for letting her kids go with a babysitter just for the purpose of a Yankee game. I couldn't believe it because the reasons for the mother going to a Yankees game had nothing at all to do with any of the liability issues in the case. But the jurors in a focus group had completely disregarded what was really the merit of the case, which was a dangerous park where the drowning occurred. A week later, I tweaked the facts a little bit just to see how the jury would respond at the focus group. And in the second focus group, we told the jurors that the mother had dropped off the kids so that she could go to the Bronx to see her dying mother in her last days of her life. And the jury responded unanimously, that's totally fine. And they found no fault for the mother of dropping off the kids. And the owner of the park, which was a town, was responsible for the dangerous condition at that park that led to the drowning. So tweaking a little fact changed everything. Now, why do I share this story with you? Because as lawyers, we put on our lawyer hats and we think about liability and damages as lawyers do. But jurors see things completely differently than we do. And facts that we think might be totally irrelevant to them are critical to the finding of negligence. This is why the $500 that you spend to do a focus group will be the best use of money that you ever do. What you do is, to set it up, you ask a local organization. It could be a school, it could be a fire department, perhaps it's a humane or rescue society. You ask them to sponsor it for a $500 donation. You offer to bring pizza, drinks, $500 donation, so there's a lot of goodwill that's going around. And you prepare for the focus group, you present the facts for the plaintiff and for the defendant. You can do this yourself. You don't need anyone's help. You present the key evidence that you have, and then you let them ask questions, usually for about 20 minutes, and then you separate them into 2 or 3 small groups where you let them deliberate to a unanimous verdict, and you will be shocked and stunned by their reasoning and how unpredictable they are. And from one person to the next, their thought processes are completely different. You will begin to see things. You won't decide whether you're going to win the case by doing the focus group, but what you will find out is insights into your case that you never would have thought of. You will think of new questions and new ways of presenting evidence through the insights that the focus group gives you. And all you need really is 3 simple forms: a confidentiality agreement, number 1. Number 2, a verdict sheet listing the questions that the jury will be asked to answer. And number 3, a questionnaire with sort of the key information that you want to get from the focus group participants. 3 simple documents, and you can test specific parts of your case. So for example, right here you can see one of the issues in one of my malpractice cases was that our client did not follow the instructions of his physician in going for follow-up tests that were supposed to be done. And so we presented that specifically to a focus group by admitting that our client didn't go for the testing, that he's got no excuses, he doesn't recall why he didn't go, and we are not going to have any excuses for him. And asking the jurors, should we stop right now, or are there other things that you would want to know? Turns out they had all kinds of things that they wanted to know, specifically what were the protocols of the doctor for following up with a patient who is not following the doctor's advice. So this led to new insights on how to present the case that we never would have known. And all this really took was $500. And if you think about all the money that you spend preparing for trial, that $500 is the best use of money that you will ever have in preparing for trial. If you liked this video, please subscribe to our YouTube channel. Please share this video if you found that it's useful with friends or other lawyers, and I look forward to seeing you tomorrow.